Hello, I'm Vince White for White, Ricotta, and Marks, and I am answering a question today. What is the EEOC statute of limitations? Why does it change from state to state? Um, the answer is it changes from state to state because lawmakers weren't really dealing with reality when they wrote that law. Um, the base statute of limitations for Title VII is 180 days. And that is fundamentally stupid because victims of severe discrimination and sexual harassment often need time before they're ready to report what was done to them. It is fundamentally unreasonable to assume that a victim can hire an attorney and get something filed in 180 days, but that's just my opinion. Now, some states, and under the law, states that have their own human rights agency, in those states, the 180 days is expanded to 300 days. Now, the logic behind that is that the EEOC wants to work more on the state's timeline. So New York State, for instance, has its own State Division of Human Rights, a lovely organization, and they give you a full year to get in your charge of discrimination. So it'd be very strange for the EEOC to require you get it done in 180 days. So they expanded to 300 days. Now, I don't really understand why they're not just giving you the full year. I know that the law is not written that way and their hands are tied, but we could change that law. In other states, like Connecticut, for instance, and a variety of other states that don't have their own human rights organization, people who live in those states and work in those states are stuck with 180 days. So for those individuals, you need to speak to an attorney almost immediately after something happens to you. So you have the time to meet with multiple attorneys, attend multiple free consultations to know your rights, get your story down on paper, turn that story, that timeline, into a viable charge of discrimination or sexual harassment, maybe engage in some negotiations with your attorney, negotiating with the other side for you before you even file. I mean, that's all a process that takes significant amounts of time. The sooner you can see an attorney, the better. The safer your claims are, the fresher the recollection in your mind and the recollection in your witnesses' minds will be. And also, I mean, the quicker you act, the more of the text messages that are available, the more of the social media, the emails. People don't have time to destroy evidence. They're not really thinking over the course of weeks and months every morning in their daily commute, oh boy, I did do a really hateful thing to so-and-so, and if I was to destroy that email, there'd just be no evidence of it. So don't give them the time to do that, right? It's common sense. I know it's hard. I know it's very, very difficult, and you may or may not be able to overcome the emotions that you're experiencing to do that. But if you are able, do so. And if you're not, maybe seek the help of a mental health professional. You're going through a lot. They can probably help you. And part of that help might be them guiding you to seek closure by pursuing these claims that you have that could be very valuable and also will prevent these bad people from doing bad things again. Hopefully they'll learn their lesson. So I hope that answers your question. If you are in a different state, feel free to contact us. We can tell you if your state has a local authority or not, and that will help you determine to some extent what your rights are. We also like to link people. We don't give legal advice outside of EEOC representation in states beyond New York. However, I can link you to something that has what purports to be answers for you, and you can question your local attorneys about it. All right? I hope that helps. Take care.